Good morning, colleagues. We've already formed a quorum, and it's also time for us to start. So let's start our meeting. Item 1 on the agenda, meeting with the government. We'll invite the government officials to enter the conference room. At the last meeting, we already started clause-by-clause scrutiny. And at the last meeting, we completed scrutiny of clauses 72 to 80. So today, we'll start with Part 5, Division 1, Clause 40. That is page C3473. Page C3473. In a moment, members can raise their concerns. As in the past, we have the Deputy Secretary for Food and Health with us, as well as colleagues from the Food and Health Bureau, Department of Justice, Food and Environmental Hygiene Department, Buildings Department, Lands Department, and Planning Department with us. So I'll invite the government to take us from Part 5. Thank you, Mr. Chairman. Before I introduce the provisions to you, at the last meeting, members asked about the glossary. There are 3 volumes. I've brought them here today. They set out the use of various expressions in which provisions. So now we'll proceed to Part 5, Operation of Columbaria, Requirements about Agreement for Sale of Intimate Rights. May I refer you to page C3473. First of all, Clause 40 on the interpretation of Part 5, as well as Schedule 4. In accordance with the advice of your legal advisor, will slightly amend the heading by adding Schedule 4 to it. There it is said that in this part in Schedule 4, what the definitions for purchaser and seller should be. And then later in 41(5) will give you the details. Now, Clause 41. Under what circumstances the seller cannot enforce certain provisions in the agreement for sale of intimate right, because if the tenancy agreement is subject to a duration, then he does not have the right to sign any agreement that goes beyond his right. In bracket 1, it stipulates that this section applies if a person, seller, enters into an agreement with another person, that is the purchaser for the sale, to the purchaser of an intimate right in respect of a columbarium. After the bill is enacted, this provision will apply to all signed agreements. Mr. Abachan, I have a question. Concerning the scope of the intimate right, well, you know that there are different forms of sale and purchase for columbaria. In law, some people just purchase the niches. But sometimes in the agreement, it is specified that the purchaser is only paying a management fee. He does not own the title to the niche concerned. So by intimate right, does it cover management right or management fee? And what about this management fee issue? Thank you, Mr. Chairman. Thank you, Mr. Chan. Intimate right involves a number of things. We took reference from a number of agreements in the market. Most of the agreements only spell out the right to use, that is the license. We do not rule out that in certain cases it may take the form of a tenancy agreement, and very rarely it takes the form of a title. So it's just like the right to use a mini storage space or a go down. It's just like on page 3389. And 3401, on page 3401, we clearly spells out what intimate right means. We try to set out all possibilities. We'll disregard the format. We would like the bill to cover as many scenarios as possible, such that the parties concerned will have to abide by the provisions. Well, please give me a simple answer. What does this cover? If you look at the definition for intimate right, then you see from page 3389 what are covered, irrespective of the duration. And then for the sale of intimate right, you can refer to page 3401. Be it completed or incomplete niches, whether or not the niche concerned is already vacated, etc., etc., we require the agreement to spell out very clearly whether it's a right to use or a title, and so forth. May I ask our legal advisor to go through the interpretation of the government and what they mean by management agreements. That is, no title is involved. Has the government addressed my concern? Can our legal advisor help? Well, so long as the ash is stored in the Columbaria, then it will be covered. All right. Another question is about breach of agreement. In the past, I handled quite a number of cases about car parks. You know that the big consortia own the management right as well as the title to the car park. In the past, many big consortia, upon occupation, lease the car parking spaces individually. Obviously, this is against the land grant because they're making a profit. We complained to the Commercial Crimes Division of the police, but in vain. Well, they colluded, say, by $2,000 per space. They may be occupying dozens of car parking spaces, and then they may make a monthly profit of hundreds of thousands of dollars. That's against the land grant. So if car parking spaces can be leased on a monthly basis, what penalty will you impose on them? Because in the past few decades, they're making such profits, nobody could control them. What's your question? Well, in future, say if you approve 5,000 niches, but they provide 6,000 niches, will our provisions be sufficient to regulate those activities?
As we said in the past, if they apply for a license in accordance with sections 13, 14, whether it's a pre-bill columbarium or non-pre-bill columbarium, it has to meet with the requirements of the land leases and also the land instruments. If it can't meet with the requirements, it can't get a license. I would like to supplement that. You quoted the case of a car park. What do we mean by interment right? We would include cars as well if they are stationary. You asked about the penalties. May I refer you to C3408 to 3410? It says that if it is convicted through summary offences ordinances, a penalty of $2 million and also imprisonment of 3 years imprisonment can be imposed, and also $5 million in fine and 7 years imprisonment may be imposed. So a number of parties may be involved. So who are you penalizing? Are you penalizing the owner or those who contravene the requirements deliberately or willfully? Well, it's just like the case of a catering establishment. Somebody who should be responsible is held accountable ultimately. In sections 8 and 9 of the ordinance, of course, we have to give the relevant proof, present the proof. Those who have been caught will be held liable. And in sections 9.2, page C3408, is that a person who operates, keeps and manages the Columbarium will be held liable. Mr. Raymond Wong. I have a question on section 41 bracket 2 bracket A. There is a sentence. There is a question or a problem with the punctuation mark here. For Columbarium premises occupied under a short-term tenancy from the government that is renewable on a periodic basis, and there is a comma in the Chinese version. Why should you need a comma there? On a periodic basis and terminable on notice given for a specified period. I don't think there should be a comma in between the two meanings in the Chinese version. Draft the DFJ colleague, please. 41 2A. Under a short-term tenancy, there are two descriptions. One is it is from the government, and second, it can be renewable on a periodic basis. So that's why we use a comma in between the two phrases. These are two separate matters. So there are two features to this short-term tenancy. That is, it is issued from the government and that it can be renewable on a periodic basis. Well, in the English version, there is just one sentence without a comma in between. While the English sentence flows differently. In English, it's a short-term tenancy from the government. In the English language, we can use the word that to connect the two meanings. And after that English sentence, you have a semicolon. In the Chinese sentence, you have the same semicolon. But then the comma in the Chinese version is very misleading, because this is a Chinglish here in the Chinese version, and it doesn't flow smoothly in the Chinese version. Well, that aside, also in C, the English and Chinese versions are different. In the Chinese version, there is a sentence in a bracket, but in the English version, there isn't any sentence in the bracket. How come that there is this difference? In subparagraph C, we think that a bracket in the Chinese version can bring out the meaning and the concepts clearer. In C, there are different elements, and that is selling an intimate right, and then that is for a term that extends beyond the term of three things: a lease, license, or other instruments. And there is another message in that subsection to be brought out, and that is under which the land on which the columbarium is situated is held from the government. So to make it clearer to the readers, the different meanings and the relationships between the various terms, and that is the way that it is proposed. I think the drafting is very cumbersome here, because you haven't been able to do it to write it clearer in the Chinese version. You're incapable of doing that, so that's why you add in a bracket here. And also, there is the last sentence in the Chinese version, and that is in the Chinese version is that the seller is not entitled to sell. In the Chinese version, it is that sentence is put at the very end, and it is so very unclear, the meaning in the Chinese version. Yes, you've heard that view. See if you can improve on it. Let me try to explain. In the Chinese version, the agreement is not enforceable by the seller. Well, both the English and Chinese versions carry the same meaning. In the Chinese version, we bring out the conditions first. Subsection 2, if blah, 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 ABC. And then the seller cannot enforce the agreement. And that is the conclusion of the conditions. But in the English version, we can have the conclusions first before setting out the conditions there. So I think our principle is to try to make it clearer and smoother in both versions. And I'm sure that the readers would like to read the conditions first before the agreement is enforceable. So I don't get it. Anyway, Chairman, let's leave it like that. It's not just 41, but 41.1, then PS. Please take us through subsections 2 and subsection 3 first, and then we can have questions asked. Mr. Raymond Wong has already touched on subsection 2. Well, okay, let me go through subsections 2, 3, and 4 first, and then we can take questions at one go. Now, subsection 2, if the seller sells rights which are beyond his rights, and that is the conditions A, B, C, then the agreement is not enforceable by the seller and the purchaser. Well, the agreement is not enforceable by the seller against the purchaser, and that is to say, if the purchaser hasn't paid the money, then he doesn't have to be paying the money, and if he has paid the money, then the money should be refunded through a court order. Now, A, B, C. A, it has to do with short-term tenancy. The Lands Department and the government very often will issue a STT, and these are on short-term basis and can be renewed on a periodic basis. And if the government gives a notice, say for usually for in a short period, 1 to 2 months, then the government can terminate the STT. Now, if the seller holds the premises on that basis, he cannot sell interim rights beyond the period of the STT, and that it should also sell an interim right in respect of the premises, otherwise than for payment payable on the same periodic basis. And B, we said that in section 14, that has to do with pre-bill columbarium right. The operator may not be the owner of the land or the premises. He might just be renting the land from the landowner. And it says that if he is occupying the premises under a tenancy or lease, the interim right that he sells should be for a term that cannot exceed beyond the term of the tenancy or lease. And third, C, by selling an interim right for a term that extends beyond the term of the lease, license, or other instrument under which the land on which the columbarium is situated is held from the government. Otherwise, the agreement is not enforceable by the seller against the purchaser. Now, if in the transaction there might be certain conditions that he has to meet from A to J, B, C, D, E, and up to J, that sets out the content of the agreement. A, S, G, H, I says the seller has certain obligations. For example, he has to explain the agreement to the purchaser, and also a copy of the agreement has to be provided to the purchaser. So that's in two parts. So I will take you through the clauses one by one. A. Yes. Unless the seller has satisfied the following conditions, the agreement is not enforceable. A. The seller held a license in respect of the columbarium at the time when the agreement was entered into and still holds a license at the time of enforcing the agreement, i.e. he must be the license holder before he can sell the interim right. B. The agreement should be in writing and should be signed by both the seller and the purchaser. C. The agreement should set out in clear language. 1. The recommendations of Schedule 4. We will take you through Schedule 4 later on. And 1 has to do with Part 1 of Schedule 4, and that has to do with the information recommendations. And B, a comprehensive description of the rights and obligations of the seller and the purchaser under the agreement, including but not limited to the matters specified in Part 2 of that schedule. D. The agreement should set out the purchaser's cancellation rights under Section 42, and that is to say, if the seller cannot enforce the purchaser, the seller should notify the purchaser, and then the purchaser should be refunded the payment. And that is set out under Section 42. The agreement also includes other things. For example, if the ashes have been interred in the niches, and if the niches are going to be resold, then it might be somewhat difficult. So the agreement should set out that whether the purchaser's cancellation rights should continue after the ashes have been entered, because the purchaser has already used that interim right. So how he should exercise the cancellation right and what the conditions are, these are set out in Section 42 and the agreement. F. Before the purchaser entered into the agreement, the seller has explained to the purchaser the information, recommendations, rights, and obligations as set out in the agreement, and that is the things set out in C. G. The seller obtained the purchaser's acknowledgement in writing that the explanation referred to in paragraph F was given to the purchaser. H. The seller delivered to the purchaser a copy of the agreement as signed by the purchaser. A copy of the agreement should be provided to the purchaser.
Say if the seller and the purchaser have signed the agreement, then the seller has to deliver to the purchaser a copy of the agreement as soon as possible, by personal delivery to the purchaser, by registered post to the purchaser, or in another manner if the seller can prove receipt of the copy by the purchaser. And J, any other requirements prescribed by the licensing board are met. As for bracket 4, as I said, there are two categories. B, C, D, E, J are about the contents of the agreement, and A, F, G, H, I are about the certain sellers' behavior and acts. Take, for example, the delivery of a copy and so forth. Now, all these have to be followed. Failing these, the purchaser has given the seller notice of cancellation under Section 42, bracket 1, and the seller has refused to pay the purchaser the amount payable under Section 42(2). That is, when the agreement is cancelled and there's no such payment, then a litigation can be taken out in court to pursue the legal fees and charges. All right, members can discuss all these provisions in detail. Mr. James, so, Mr. Chairman, there are two questions. I heard that in Japan, there are similar facilities. When you purchase the facility, you go into a room and there's an electronic arm to take down the ash. Well, it should be okay. I don't know how they lump all those together, but it should be okay. Then during the festivals for grave sweeping, they will use electronic arms to bring down the ash. I don't know whether this particular bill can cover those facilities. Mr. Chairman, during the era of Dr. Yok Chow, we did go to Japan to observe how electronic arms, so to speak, were used to take down the ashes for worshipping. But if you look at page C3389, you see that the right of interment is not confined to such niches. So we believe that even with the use of electronic arms or movable niches, these provisions will still apply. Well, what about those vacant niches? Well, you mentioned the vacant niches, but what about a specified niche? Should there be clear markings on the niche concerned to specify whose ashes are in it? Well, because the prices of niches vary greatly depending on the direction and so forth. Well, in a moment, we'll look at Schedule 4. In Schedule 4, a lot of information have to be provided, say the license particulars as well as the details of the niche concerned have to be spelled out. If you look at page 3609, the niche particulars, serial numbers, size, right of interment, nature, etc. So, for location, in 2B1, that's already covered. The serial number and the size as well as location should be spelled out. Well, I visited some of those facilities and they spelled out all the details. Different niches have different prices. We'll say if there is this very expensive niche with a very good direction, conceptually, for a short-term tenancy of a particular duration, theoretically, if the government is not to renew the lease, then of course they cannot renew the agreement. Now, say there's this niche with a very good direction that costs over $1 million. Well, if the government is not to renew the lease with the operator, then what will happen to the person who, that is the purchaser, who sells an agreement with the seller? So should the seller try his very best to renew the lease with the government? Otherwise, the purchasers will lose out. Well, they're spelling out the responsibilities of the seller. So I think they should include a provision to the effect that the seller should try his very best to renew the lease with the government. That is, the seller should not be deliberately lazy, or otherwise the government may not renew the lease with him. Well, there are two parts here. First of all, the seller has to try his very best to maintain the niches. In a moment, we'll come to those provisions which spell out clearly how the ashes and niches should be maintained and managed, as well as the fees and charges, management, etc. As for direction and location, let me add that we did take photos in the former Columbaria. There are layout plans clearly specifying the locations. So we'll have very strict requirements on the location, direction, etc. of each and every niche. Mr. Chairman, I know of certain strange, well, maybe not strange, but religion-specific niches. Say they put niches of the same religion together. Now, what if Buddhist niches and Protestant niches are put together? Well, will the purchasers feel disturbed? Are there any safeguarding provisions here? Yes. Well, religion is just one example, but the general provisions apply to religion. If you read page 3499, you see provisions governing suspension of services, because sometimes niches may have to be temporarily relocated. Still, the operator has to follow the terms in the agreement. The seller cannot casually and randomly move the niches around. The seller has to follow the agreement. Mr. Chairman, I'm not talking about the general principles. What about direction, etc., etc.? The features and environment have to be spelled out in the provisions. Next. For this part 5, for protective provisions for the seller and the purchaser, I believe in future, well, this is Mr. Leung Chi-Chang, for the existing Columbaria, even with an agreement, if there is a dispute and certain provisions are not observed, in future in the bill, will you spell out clearly that these existing operators should tidy up their existing agreements? And will you require the terms in the agreements to include statutory provisions? Well, Mr. Chairman, Part 5 applies to all agreements signed after the enactment of the bill. Now, before the enactment of the bill, there are cases with agreements and cases without. Well, I think we have to accept reality. We cannot impose a retroactive effect on past niches. Well, after the enactment of the bill, an agreement is required. Then the terms of the agreements have to be observed. So you only regulate those after the enactment of the bill, and you disregard previous cases. No, they have to follow the terms in the agreements. Oh, yes, but that's when there is an agreement. But the bill won't be able to regulate past cases. Well, for past cases, agreements have been signed. It's very difficult to require them to retroactively observe the provisions in the bill. Say if in a columbarium there are 30,000 niches, an oversubscription. That is, in actual fact, the operator did not have 30,000 niches. So after the enactment of the bill, that operator can still continue to operate on the basis of previous agreements. Say there are actually 30,000 niches, but they sold 40 or even 50,000. But of course, when certain niches are vacated, they can have new users. But what about these past cases? Well, you're talking about the existing cases, that is, existing before 2014. The 18th of June 2014. Now you mention oversubscription. Well, I was only citing an example. Well, I think the customer should know clearly what he had bought. If there's no license, how can sellers pursue compensation? We do a lot of consumer education. Well, the agreements are already in place. It's just that the consumers did not know the facts, so they were cheated. Understand that for legislation, you have to draw a line somewhere for commencement. Well, after the enactment of the bill, all new Columbaria facilities will be regulated. But what about the previous ones? There are no laws to regulate them. Well, in fact, under common law, if the consumer can prove that the operator is in dereliction of duty or is in negligence or whatever, leading to the purchase of the niche, then the purchaser may be sued for breach of contract. And then the purchaser can start a lawsuit to pursue compensation. Well, then after the enactment of the bill, will you still grant a license to such operators? Well, there are provisions for the licensing authority to handle such applications. I believe the authority will have to consider the prevailing circumstances. Well, I don't understand your answer. Well, if this bill is enacted, what about the Columbaria already in existence? You won't be able to regulate them, right?
So you will be criticized that the piece of legislation is useless and it can't help the public. So I wonder whether in this particular part or division, you can add in something to enhance your protection of the consumers. P.S. Thank you, Chairman and Member. When we drafted the bill, we had lengthy deliberations internally. The legal experts from the DOJ had were involved. The legal policy colleagues were involved. We had to strike a balance. It would be very contentious if we allow retrospective effect of new laws after the bill is enacted. I believe that the bill will help enhance consumer protection and strike a balance between the interest of the various parties. But for niches sold before the enactment of the bill, I'm afraid that can't be dealt with by the bill. So I will wait for the next round. Mr. Wong Kwok-hing, followed by Mr. Wu Chi-wai. Thank you, Chairman. I have several questions for the administration. I wonder whether they have addressed my concerns in the bill. The first question: the seller may come up with agreement for the purchaser. Do we regulate the fees specified in the agreement? We have held many press conferences highlighting the problems being encountered now. For example, the offerings were sometimes specified in the agreement. Different types of donations required are also specified in the agreement sometimes. Does the bill cover all types of fees charged by the seller? That's the first question. Second, when the seller sells the niches, will the seller specify that ashes of other family members can be put in the same niche in the future? That's the second question. Third question: would you regulate the pre-sale of niches by installment payments? Is there any regulation on that? Fourth, would you regulate sellers selling niches through intermediaries? The intermediaries may charge a commission. And as a result, the consumer's rights could not be protected adequately. Well, just like the case of selling flats, housing flats now. So 4 questions from me. Have you covered all these in your bill? I would also like our legal advisor to study the 4 aspects I mentioned. PES, please. Thank you, Chairman. First question: in setting the agreement, the charges involved, the details of the charges and so on. Yes, we do cover this aspect. In Schedule 4, there are detailed provisions. I will talk about them later. But for now, I would like to say that in page C3400, when we talk about selling of interment rights, in bracket 2, we say that whether it's a one-off payment or payment by installment, or is it in the form of offering or donations and so on. On page C3400 bracket 2, that is already covered. And in Schedule 4, in C3610, if you look at subsection C, we said that a comprehensive list of all fees, charges, or other sums payable by the purchaser must be listed, whether these fees are recurrent or non-recurrent in nature. The seller should specify the precise purposes for which the fees are paid, the amounts of the fees, and also the payment methods, and whether there will be increase and future revision of the fees. All these have to be set out clearly. That's number one. Number two, whether the purchaser can put in more ashes in the same niche he buys. As we all understand, we try to strike a balance in this bill. We want to strike a balance among the seller, the buyer, and those living in the vicinity of the columbarium. As to the number of ashes put in a niche, if you look at section 46, that has to do with the number of sets of ashes in the niche. We have also spelled out earlier on in the bill in the number of ashes, the locations of the niches, and so on. All these are well defined. So the number of sets of ashes interred is subject to our provisions in the bill. Third, about payment by installment. As I explained in subsection 1, that we've got provisions dealing with payment by installment. And fourthly, if the seller or the operator sells through an intermediary, the bill regulates the columbarium operator. We require the operator to set in the agreement the purchaser and the person who puts in the ashes and the authorized persons. All these are set out in the provisions clearly. The seller may sell or resell the niches through an intermediary, but then for the users, the dedicated persons, and the authorized persons should be spelled out clearly. Mr. Wong, I don't think the administration has answered me. You talked about only seller or the purchaser, not the seller. You don't have any provisions regulating the intermediaries. Do you have such provisions? The agreement is signed by the seller and the purchaser. And if the purchaser wants a name change, it has to do so in accordance with the provisions in the agreement. The member talked about the intermediaries, just like how estate agents work in sale of housing flats. Well, that's altogether another matter. I think we should take a gradual and orderly approach on this. I think we can't do everything at one go here. Mr. Wu Chi-wai. No time for you, Mr. Wu Chi-wai. Thank you, Chairman. Several points here. The PAS said that the bill can't deal with pre-bill columbarium and their sales records and agreements. Would you consider that after the bill has been enacted, you would require the licensed columbarium to make certain transition arrangements for past agreements signed, and that is they should sign new agreements containing old terms and clauses so that the purchases can be adequately protected. So that means that in the same columbarium, all the agreements will be the same and consistent, or else we would be ending up with a situation where it is very bizarre in that there are some old agreements and that there are some new agreements in the same columbarium. Would there be any transitional arrangements? If possible, there should be a mechanism after the amendment of the bill for allowing the old agreements to be turned into some new agreement. Okay, let's do it point by point. Please answer that question first. BAS, can you consider that? Yes. If you look at C3478, for the records to be kept, all the licensees should keep a record of old agreements, copies of such old agreements. We also require them to keep a register of agreements and the details of such agreements in this register. Now, the member suggested transforming or changing the old agreements into new agreements. I don't think it's difficult to do that. Perhaps the PS has misunderstood me. In this Bills Committee, we have said many times that there have been niches where ashes have been interred. There are all kinds of agreements in place. I'm sure the PAS is well aware of this. Since in the bill there are such clear stipulations, and also I assume that there is no dispute between the seller and the purchaser. If the operator has all the records and keeps a register, and the operator has to sign an agreement with the purchaser complying with regulations of the bill. I'm not asking you actually to change the old agreements to new agreements. I'm just saying that some transitional arrangements should be put up to change the old agreements into new ones which can comply with the ordinance. PAS, if both sides agree to change the provisions in the agreement to tie in with the latest agreements, and that I welcome that. But it's difficult for us to mandate by law for them to do so. Legal advisor, can you try to advise us on whether it's legally feasible to do that? Ms. Cole or who? If this is the requirement, that has to be set out clearly in the bill. Legally speaking, is that doable or feasible? Unless that requirement breaches other legal requirements, that can be drafted within the bill. Perhaps we have to ask other government departments' colleagues to see if such a requirement will contravene other laws like the Basic Law and so on before we can write in such a requirement into the bill. Mr. Wu, I hope that the government can seriously consider it. Because with some old agreements, they come in all types, and it is very questionable that they are, in fact, good agreements. And sometimes the agreement will say that a niche will be given to you if you give an offering, incense offering, and to the buyer that may be an agreement to them already. So I hope that the seller should discharge his responsibilities duly. And for some columbarium, because there are restrictions in the land lease, and then the purchaser can't retain his niches in the columbarium, then that might be legal disputes and so on. And I think the earlier the disputes can be handled, the better it is.
Therefore, I suggest and very much hope that if technically possible, there should be a provision to require the columbarium operator to start another process with the purchaser to change the old agreement into a new agreement. Dr. Priscilla Leung, well, can the Bureau undertake to do that? Perhaps I should elaborate. We previously discussed this with some lawyers. We have to protect property rights, private property rights, human rights, etc. I don't think we can do that 100%, but for the basic terms, if there are no conflicts, we can go back and discuss further with our lawyers. But there may be actual difficulties. For example, in a past agreement, they only specify that you can make some donations before you can occupy the niche. So how to make such arrangements for old agreements? We can go back and examine the issue. Dr. Priscilla Leung, Mr. Chairman, all along we've been saying that Columbaria facilities involve many generations. Some old people may not have offsprings, and they may assign agents to act on their behalf. That's why in the past when we mentioned legislation, we asked the government to avoid having a recurrence like the Lehman Brothers incident. So during the transitional period, there may be cases emerging such that the parties concerned may need your assistance. It's just like the welfare agencies. Very often they act on behalf of those elderly persons with no younger generations. Now, for these niches, when it comes to agents and so forth, under the new law and the new policy, you should consider the registration system. Of course, niches or graveyards fetch a much lower price than, well, residential flats for living persons. Maybe just $200,000 are involved. Anyway, the registration system has to be clearer. And just now, some colleagues asked the government to follow up on past agreements. I personally have reservation over this. In law, the new policy should avoid retroactivity. Yes, somebody might have signed agreements without understanding fully the terms of the agreements. But you have to respect agreements. There are contractual terms in those past agreements. So during the transitional period, the government should consider how to assist such parties. Now, if you mandatorily require all past agreements to observe the new provisions in the bill, there may be difficulties. But I was involved in a number of litigations. I got a number of cases in Hong Kong. Well, if people chose to go to court, there's no alternative. There's nothing you can do. But can the government consider extra assistance for those affected by past agreements? There may be ambiguities in existing agreements. I started to talk about these a few years ago. So while institutionalizing or regularizing existing conditions and terms, you should consider existing cases. Well, I believe sometimes there are just verbal agreements. So how will you handle those? Well, we'll now focus on the bill. For corresponding issues. Well, I think you'd better answer the question first. Well, concerning the agents for residential flats for living persons, as well as these niches, if you refer to page 3479, you'll see that we require records to be kept to reflect the particulars. Of course, the register is for the director of FEH. But I understand members' concerns. If the parties concerned would like to peruse the particulars about their own niches, well, I'll go back and look at this. What about the system itself? You really have to consider a discretion. Well, you don't want these people to go to court. So if by way of system or policy, can you provide assistance to those niches that have problems under the bill? Well, I think we've been repeating the same issue. Any supplement? Well, let me supplement. Our next step will be to look at the ancillary measures, but give us some time. We took reference to other departments. Say, we try to refer to the social workers and their experience. For example, can assistance be offered to social workers to assist those deceased with no family members or relatives? Can social workers, say, participate in the balloting process on behalf of their clients? Well, the Director of Food and Environmental Hygiene will handle all cases in a manner that is considered appropriate by him. Well, of course, we may contact the descendants of the deceased first. Failing that, maybe we'll enlist help from social workers. So, failing all those efforts, the government will come in at the end, right? Yes. Mr. Paul Tse? Well, let's come back to the statutory provisions. I think broad policy matters should have been discussed much earlier. Now, let's look at these few clauses. Understand that to start afresh, the government would like to do everything properly and appropriately. In past experience, we might have found abuses, blackmailing cases, etc., etc. But I think we're looking into excessively fine issues. At the moment, the industry members are small operators only. They are not big land developers, so you should help them. You see, you require a copy to be delivered upon signing of the agreement, etc., etc. It seems that you're going into too many nitty-gritties. Beyond statutory laws, we also have the common law, and we have a lot of mechanisms to protect the consumers that we can use. Well, unless you tell me that you're eliminating common law as well as mechanisms to protect the consumers, this bill is actually an additional protection. So do you need to go into such details? Well, in fact, the seller and purchaser should have the right to give up the agreement by way of a notice within a certain time frame. in purchasing a niche, after signing an agreement, if you cannot complete the processes after some years, the purchaser may require the seller to pay a refund. Well, under the existing provisions, do you need to go to that extreme? Well, for residential flats, for living persons, we have provisional agreements for the seller and the purchaser. For these niches, the purchaser signs the agreement and passes it back to the operator, etc., etc. You see, at present in the market, we have a wide variety of agreements. Well, if members are of the view that these provisions in the bill are too fine or excessively fine, then we can go back and reconsider them. In future, we'll produce templates for reference only. In Taiwan, they also have templates for, say, agreements. Now, before the ashes are interred, as we said, so long as the ashes are not yet interred, that's another scenario. But after the ashes are interred, it will not be very easy for the agreement to be cancelled. Well, I think Mr. Wu Chi-wai's suggestion is impracticable. He's talking about ideals, not reality, be it unauthorized building works, even for the land titles ordinance. We've been discussing the provisions for years, but in vain. Well, he had good intentions, but he did not understand the actual circumstances. Even for the new agreements, I agree that you should promulgate guidelines and templates. But if you have so fine details in the bill, so much so that in future a seller can ask for a refund from the purchaser, then I think you're going to the extreme, because you're not talking about charities. Well, I think you should ask the parties concerned to hire a lawyer first. Otherwise, they may fall into traps unknowingly. You shouldn't deviate too much from the common law. For contractual breaches, well, unless they are fundamental in nature or very serious in nature, you shouldn't allow the agreement to be cancelled so casually. Well, you see, under these provisions, if a record is not kept, the agreement can be cancelled. Have you ever considered that the result of these provisions may be that after many years you'll have a lot of disputes? Well, we'll go back and consider members' views, and we'll study Schedule 4 as well. Say, we'll only regulate the fundamental principles, but for the nitty-gritties, maybe we should not impose a heavy penalty. No, I'm not talking about heavy penalty. All lawyers understand what I'm saying. If you allow trivial breaches to lead to a cancellation of agreement, then you may end up with blackmail, extortion, etc. So should you be so strict in these provisions according to contractual theories? So I think you have to be fair to the industry as well.
Yes, we'll go back and take a look. I think the Mr. Porter's remarks are well-grounded. Looking at what's actually happening, there is a great demand for niches, and if it's quite improbable that people will cancel the agreement. And we should not go having such fine details in the provisions in the bill, or else there will be grave consequences. So I don't think there is a great problem on that front, and we should not be so strict in our provisions. Well, only when there are major problems will purchasers be allowed to cancel the agreement. That's my view. The legal advisor. Thank you, Chairman. I have a question on Section 41(2)(b). It sets the tenancy or lease, but no other instruments. Well, we will add back the term other instruments. Yes, legal advisor, please. 41(3)(j). It says any other requirements prescribed by the licensing board. Do these other requirements have to do with interment rights or not? And will they be drawn up or specified in the form of subsidiary legislation? As this is a section in relation to requirements about agreement for sale of interment rights, may I refer members to C3548. The licensing board can, with the approval of the Secretary by notice published in the Gazette, amend Schedule 3 to 4 or Part 2 of Schedule 5. So we would do it by way of subsidiary legislation. He may set the requirements through that channel. I have a question. We mentioned about the pre-existing agreements. We would respect those. But in reality, many Columbaria have sold off all their niches, and a number of them have not been occupied or taken up yet. The number is quite big. So the purchasers can actually resell the niches themselves. Perhaps they will buy the niche at a price of $30,000 to $40,000, and now the price may go up to, say, over $100,000. Will that be a sort of speculative or profiteering activity? In Kowloon City, there are shops advertising niches that can be sold. So after the bill is enacted, will there be regulation of such commercial activities? Because such activities will go against what we aim to achieve in our bill. We should prevent speculative activities. What can you do under the bill to prevent such things happening? Yes, please queue up later. I would like to ask the chairman, what provision are you talking about? Because I was just next door having a meeting. You were talking about the entire bill. Which particular section were you talking about? Sorry, I just came from the meeting on sexual violence. 41, 1 and 2, 41 and 42. Chairman, you had a very valid point. This is exactly what we're worried about. In the notification scheme, we also were alerted to such a situation. So in drafting the bill, we were, in fact, worried about the situation. So we took the stricter view of things. And only when the niches were used, then the columbarium will meet the requirement of the pre-bill columbarium. So even if the agreement is assigned, the columbarian cannot apply for exemption if the niches of the ashes are not interred. We would study the matter further. Of course, there are buyers who are real, genuine users. They would like to have the niches to be taken up by the ashes of their families. Some of them have the ashes interred, others not. And there are people who are actually trying to profiteer from the case or the situation. So I think we would look into it, and then after the summer recess we will come up with proposals and discuss them with the Bills Committee. This is a major problem indeed. There have been sudden expansions of Columbaria because there are people who would like to profiteer after the bill is enacted. Ms. Chen Yunhan, I have no question yet. We are now on part 5, sections 41 and 42. There has been a clash of meetings this morning, so I just came from that other meeting. Thank you, Chairman. Ms. Sitho, thank you for raising that question. I would like to follow up. In the bill, there is the word mortgage here. Well, my impression is that there may be cases where the prices of niches have skyrocketed and purchasers have to take out a mortgage with the bank for purchasing a niche. Is that really happening? PAS, can you confirm that? And also, there may be speculation on old niches as well. So has the government considered regulating such activities? Perhaps a descendant is in financial difficulty and he may sell the niche of his ancestor so that he can get some money. So have you thought about regulating such cases? I think you are talking about C3606. Well, when we talk about mortgage, we are talking about the mortgage of the operator and not the purchaser. In the agreements in the market, many of them are buying not the ownership right or property right, but rather the use right. So here we are talking about an operating having a mortgage or any other encumbrance in their premises. So, Chairman, that's why I said that was only my first impression. Now I understand that it has to do with the mortgage of the operator. My question for the administration is, have you noticed any resale or speculative activities of the niches? And how are you going to protect the consumers if there are reselling of niches in the market? We've checked. There are premises, Columbaria premises, that have taken out a mortgage. Well, just the premises, not the purchaser. Yes, just the operator. I'm afraid that there may be speculative activities on the niches, just like housing units for people or car parks. I don't think we should encourage speculative activities of niches. There may be resale of niches though, and how are we going to protect the last buyer? So this is what I'm concerned about. Ms. Chen Yunhan, the PAS said that operators may take out mortgage on their premises. Now, well, we're talking about the operators taking out mortgage. So let's say if it is a building block and a mortgage is being taken out, and if there are problems with the mortgage, and what is your protection afforded to the purchasers of niches in this mortgaged block? We haven't discussed that. For properties and land plots in Hong Kong, it's common that there are mortgages. And if the mortgages has taken possession of the premises, I think we have provisions to deal with those. There are indeed regulations on these matters or provisions in the bill on that. I don't understand Ms. Wong's remarks. If there are problems with the mortgage, the operator should refund the users, right? But that's very theoretical. In reality, that won't happen. Well, have you said something about the refunding to the purchasers? No, we said that there are provisions dealing with how to dispose the ashes. Now, if an operator has taken out a mortgage and he goes bankrupt, then what will happen to the buyers of the niches? And some buyers may have already got the ashes of the ancestors interred. What will happen? How can a refund be made if the operators had gone bankrupt? PAS, please. In Part 7, we have detailed provisions covering the case of a operator going bankrupt. We have provisions on how to dispose the ashes and whether the disposal is made properly. It won't affect the purchasers making a claim through legal means against the seller. Claims can be lodged. In bankrupt cases, we have priorities. So in Part 7, do you have a list of priorities of the creditors? We have considered that internally. We have sought the advice from lawyers. We have difficulties in coming up with a priority list. For example, the employees will get high on the priority list. We have thought about coming up with a priority list, but then we haven't done so. Well, we will go by the usual principle in relation to the priority of the creditors in bankrupt cases. Well, money is one thing, and ash is another matter. Well, we've got existing mechanism to deal with the monetary disputes. So when we get to Part 7, I think we can further deliberate on it. I would like to thank the legal advisor for raising a question. Part J. Any other requirements prescribed by the licensing board? The PAS referred us to Section 91. I think the provisions there are clear, and that has to do with Schedule 3 or 4 or Part 2 of Schedule 5, and also Schedule 6 or 7. Apart from that, any other provision is not subject to Section 91. And for subsection J, there is a big question mark. What will happen if the licensing board has any other requirements? If that is J is subject only to Section 91, should that be set out very clearly, or else the licensing board will be coming up with very broad or absurd requirements, or else the contracts will have to be cancelled.
Originally, we thought of Schedule 5 and Clause 91. As for actual operations. If members have doubts, then maybe we can pack this with clause 91 to allay members' worries. Well, if there are no further comments on this particular issue, I'd like you to turn to page C3607, Schedule 4, since there are issues related to Schedule 4. Well, Mr. Chairman, in the provisions that we just discussed, we mentioned Schedule 4, prescribed information, recommendations, and essential terms in agreement for sale of interment right. So let us introduce the provisions herein to you. That is on page C3607. Part 1 is related to information and recommendations. Clause 1, an agreement for the sale of an interment right must set out the following information and recommendations. First, information about the seller's license. After the enactment of the bill, only a licensee can sell niches. And then the license number and the validity period of the license should also be provided. B, information about ownership, tenancy, encumbrances, and restrictions on use and disposition. Roman 1, whether the seller is the only owner, one or two or more joint owners or co-owners of the Columbarium premises, and if so, the particulars of the seller's interest in the Columbarium premises. Roman 2, whether the seller occupies the Columbarium premises under a tenancy or lease or any other capacity, and if so, the particulars of the tenancy, lease, or right to occupy, including the date on which the tenancy, lease, or right is to end. Roman 3, whether mortgage or any other encumbrance subsists in the Columbarium premises that may jeopardize the purchaser's interest. Now, these information have to be provided in detail. Roman 4, whether the Columbarium premises are prevented by an instrument registered in the land registry from being used or disposed of in a manner that may jeopardize the purchaser's interest, and if so, particulars of the instrument. Let me give you an example. Unauthorized building works or legal aid. A charge can be imposed under the land registry, and all such information have to be disclosed to the purchaser. Bracket C, the term for which the land on which the Columbarium is situated is held from the government under a lease, license, or any other instrument. Bracket D, information about financial risks involved with lump sum prepayment for an interment right for a long period. If at the beginning the purchaser pays over $1 million, then he suffers financial risks, so the seller has to explain all the details to the purchaser. Bracket E, a recommendation that the purchaser should carefully consider whether the purchaser's interest is protected against the financial risks, the risks spelled out in bracket D. Bracket F, a recommendation that the purchaser should seek legal advice if the purchaser does not understand any part of the information, recommendations, or terms in the agreement. Any comments? Mr. Wong Kok Heng. Mr. Chairman, I'm sorry because just now I had to attend the meeting next door. I understand members have to go to and from conference rooms. Where are you now? Well, I'd like to ask about Clause 42. I was concerned about Clause 41. You're already on Clause 42. I'm concerned about Clause 41. Now, you mentioned agents. The answer was that nothing is provided in this bill, depending on future developments. At the moment, sale of niches is not being regulated. Yet, such activities already exist. Now we're discussing the regulation of private columbaria. Can we add some provisions to this bill such that if the seller empowers intermediaries to sell the niches, then should we add some provisions here to regulate the seller so as to protect the interest of the purchaser? If we are to add such provisions to the bill, then in future we don't have to prepare another piece of legislation to regulate the intermediaries and agents, just like the estate agencies ordinance. I'd also like to consult our legal advisor on this issue. If at this juncture we add provisions to this bill to regulate intermediaries and agents, would it be better? Ms. Wong, in a moment your legal advisor can supplement. Just now we said that when we went out to examine the contractual arrangements of Columbaria, we observed that agreements had been signed between purchasers and sellers. Of course, sometimes intermediaries were used, and intermediaries may act as agents to sign agreements. Still, as an agreement between the purchaser and the seller. So the agreement binds the purchaser and the seller. So for the purchaser and the seller to sign the agreement can protect consumers. Of course, the honourable member may be concerned about speculative activities on the part of intermediaries. Well, due to time constraint, we won't be able to add provisions in this bill to regulate intermediaries who aim at profiteering. Well, that answer indeed proves that we do have such scenarios at the moment, and this bill won't be able to regulate those cases. Well, but this bill can regulate the seller and purchaser in relation to the location, etc., of the niche concerned. The agreement can protect the user to a certain extent. Well, the government said that they just don't have sufficient time to handle the intermediaries and agents at this juncture. So there's an actual need here. Well, if we want to, legal advisor, if we want to regulate the intermediaries and agents, then we do need additional provisions in this bill. Well, in the market, we do have intermediaries and agents for Columbaria services and facilities. They're just like the intermediaries and agents in the property market. It's just that these intermediaries and agents provide services related to Columbaria facilities. So I wonder if we can have additional provisions in this bill to regulate them as well. Government? Well, Mr. Chairman, perhaps I should explain the issue like this. The emphasis of the bill is to regulate the agreement between the purchaser and the seller. This is a very important starting point. Whether or not the two parties complete their transactions through an intermediary. Well, we shouldn't adopt a broad brush approach by saying that all intermediaries are engaged in irregular activities. In future, do we need to regulate the conduct of intermediaries? We want to leave that to the next stage, because for this exercise, we'd like to complete basic regulation first, because we know that for existing cases, sometimes they don't even have a simple sale and purchase agreement. In future, do we need to regulate the conduct of intermediaries? I think we can leave that to the next stage. For residential units, for living persons, it's also after a long time that we started to feel the need to regulate intermediaries. So I think there is this question of priority. I think we should focus on these agreements first. Mr. Wong Kwok Hing? Mr. Chairman, I hope to put on record that reply from the government. That reply indicates that the government does consider intermediaries a problem. It's just that they want to leave that to the next stage. Now, I'd like to ask the government another question. Can we protect the... can we regulate the seller by way of a schedule or a code? Then you can simplify the exercise. Well, you've exceeded 7 minutes, but nobody is queuing up. So please continue. Well, can you use a schedule or subsidiary legislation to regulate the seller? Mr. Chairman, the main reminder for the consumer is that he has to be very careful with what he signs. The emphasis of this bill is that salient points in an agreement should be set out such that the purchaser knows what he is purchasing. So if there's any irregularity, the purchaser can refuse to execute the agreement. As for the honourable member's concern, that is to regulate the conduct of the intermediaries, be it in the principal ordinance or subsidiary legislation, we need to strike a balance and we need to study all provisions in detail before we know whether or not the provisions are consistent with one another. So allow us to suggest that we leave this to the next stage. In this stage, we should tidy up the agreements as well as the basic elements in an agreement. When will the next stage start then? Deputy Secretary, I'm afraid we have to let the bill to operate for some time first. So at this juncture, I really cannot provide a timetable. Mr. Paudet, well, how should I put this? For the whole morning, I have the feeling that the bill is over-legislating. I don't have Mr. Wong Kwok Hing's worry. If we have the worry about the intermediaries as well, I have to say that in society, we have intermediaries for many activities, and even for residential units, for living persons and first-hand sale of flats, we only have a regulatory framework for intermediaries just very recently. Well, look at Schedule 4. Look at A. Are you only citing an example? And for ownership, will there be any restriction in terms of interest?
I think it is too broad here. It goes beyond what is required in sale of properties. What is can be found in the land registry. Well, a lot of Columbaria are in the new territories, and their ownership has to do with ownership of choutongs, temples that may extend it way back several hundreds years ago. Would that be excessive information required here? We now have the lands registry, and the lawyers concerned can search for information there. But now you are asking for all this information every time that a transaction is made. So that would pose a heavy burden to the operator. For example, a purchaser may purchase a niche for $200,000 or $300,000, and you are requiring this seller to provide all sorts of information relating to ownership, tenancy, and so on. Is it going too far? It goes beyond what is necessary for protecting consumers' rights. Thank you, member, for your question. For 3 and 4, there should be information in the lands registry. Member has queries on whether such information is required, should be required, or should the purchasers be asked to go to the land registry to dig out the information himself? No. In accordance with Clause 97, the HJB has certain regulations in relation to ownership of choutongs and so on. So I think we can try to simplify the clause or make it clearer. And in number 2, that the information may not be available at the lands registry. I think that item should be retained here. I think we can go back and see if we can streamline the information and address the members concerned. Even if you are now renting a shop, which is expensive, you would not be asking the seller to provide information on, say, the mortgage, the interest concerned, and terms for repayment and so on. I think what you're requiring is actually going beyond what is normally required, even for major transactions. It has to do with the privacy of a person's economic assets. I think it's right to protect consumers' interests, but are you being excessive here? Mr. Wong Kwok Hing has raised a concern here. It's not the case that we have a vacuum in the legal or the window in our legal scenario. There we can go by the common law, and there are certain responsibilities on the seller and purchaser in the common law system. That's been very clear. It's good that you come up with new legislation, but you have to strike a balance when you do the legislation. I think you are going too far in your legislative proposal. As someone from the legal sector, well, I would thank you for creating business for us, but I don't think all these provisions are necessary. Let me add, we would go back and study how we should link up with the lands registry. Now, as for the agreement for pre-bill columbarium, they don't have to own the land. It's best that they own the land, but then if they are operating the premises on a lease, they have to announce the lease period. What we're worried is that they have a lease lasting for 5 years, but then they are selling the interim right for 10 years. So that will be a problem. So that's why in item 2 we require them to give the particulars of the tenancy. I think, well, all you need to do is to ask them to set out the tenancy period, and you shouldn't be requiring them to ask for to give out the particulars of the tenancy. I think you are giving too many responsibilities to the operators. I think the demand may be excessive and they will be unduly worried, and also there may be hidden dangers if you do that legally. So I think Mr. Chair has raised his worry. Let me add, we would go back to study whether we should ask the operator to give out the exactly who the owner of the land is. Maybe they own the land themselves and they are faking that they are renting the land, and then they try to evade their responsibility as a result. So this is something that we have to be clear about. Legal advisor, I have a similar concern as Mr. Porter. B1 and 4, and particulars have to be given out on the instruments, the occupation rights, and so on. Would the government list all the particulars that have to be given out, set that out clearly? Because we are talking about serious consequences. If the particulars are not listed out, then the purchaser can refuse to execute the agreement. Yes. The lands registry is an open registry, and it contains all types of detailed information. I think we can try to see if anything can be done on that side. We could go back and take a look at all the detailed provisions, and then we will report back to the Bills Committee. The more I hear about the bill, I think the bill is complicated. Ms. Wong said that some operators may own the land, but then claiming that they don't own the land and there are problems resulted and so on. The operator may lease the land from someone and then sell off the niches to people, to users. So if it leases the land for 15 years, then it can sell the niches, say, for 8 to 10 years. But if you have the lease, a 5-year lease, and you are selling the interim right for 10 years, and that's going to be a problem. So the operator may be deceiving the purchasers in that case. So how come that the government is allowing such operators to lease the niches in the first place? Well, as I said, we hope that the operators can own the land themselves. If it is not a pre-bill columbarium, the operator must own the land himself. Now, we may have some pre-bill columbarium. We encourage them to be the landowners, but for historical reasons, they may not own the land themselves. So should we not allow them to continue operation? Now, we said after discussing with the Bills Committee, we will allow them to continue with the operation. If it is a leased piece of land, then the interment right should not last beyond the lease period. We hope they can still continue with their operations, and we will impose stringent conditions on them as well. I understand this, Chairman. In dealing with the pre-bill columbarium, should you be taking a more stringent approach? You should set or specify the period for which the niches can be sold, so that they cannot so easily cheat people. You allow flexibility for the pre-bill columbarium operator, and they can take advantage of that. While we say that they should at least have 5 years of lease period before they are granted a license. After the bill is enacted, they won't have 5 years. They will have a shorter period instead. No. If the bill is enacted, if they are not pre-bill columbarium, they can only apply for a license if they own the land themselves. No. I'm talking about the pre-bill columbarium. They can still operate on leased land, right? So you're talking about a period of 5 years. Well, less than 5 years. No less than 5 years. After the bill is enacted, then they will be having a period of less than 5 years. No. After the bill is enacted, the licensing board will deal with the license application. Then starting from the date of the license issuance, the operator must have a lease period of the land for 5 years. Well, you have agreed on that, right? Yes, we've made the calculation, and this is the approach that we will take. A lot of people discussed about the transitional arrangements, so you are all agreed on that. Yes, we've assessed the situation and we've come up with this proposal of ours. Mr. Paul Chair, on the second paragraph, we talk about the ownership and tenancy, and D is another worrying requirement. 41, 42. You said that clear terms have to be spelled out. So what do you mean by clear terms? You said about information about financial risks involved with lump sum prepayment for an interment right for a long period. If this are set out, we won't have the situation of the Lehman Brothers, and we won't be seeing the financial risks that we are seeing now in relation to remortgaging of HOS flats and private residential properties. So what do you mean by information about financial risks? You may be well-intentioned in protecting consumers, but are you doing it excessively here, making it too easy for the purchasers to cancel the agreement? So the ideal scenario is that the purchaser will not be paying one lump sum. Rather, it would be better if the purchasers pay in several payments. Now, the purchasers may like to choose or opt for a lump sum payment. So if there is a lump sum prepayment, there will be financial risks. For some good operators, they may deposit the money with a fund and they can continue their operation, and they may be putting the money in some other investment means. So what we want to see is that the consumers know exactly the financial risks involved, and the seller should be giving out the information to the purchasers so that the purchasers know exactly what the risks are. So how detailed should the information be? Well, if your intention is just to alert the purchases of possible risk, all you need to do is just add a sentence saying that there will be financial risk involved in prepayment. But if you are asking the seller to provide detailed information about financial risks, how detailed the information should be so that there will not be any breach of the requirement. So what risk are you referring to here? Risk associated with the stock market, or what? Well, you should not assume that the consumers live in Mars. Well, there are all sorts of risk in the society, and people are well aware of that. If you overprotect the consumers, you are treating them as if they are idiots, not knowing how to care for themselves. you are too keen in protecting them, and you are treating the sellers as if they are thieves.
其他保護
It sounds like we're not protected by the common law. You are doing everything afresh. You're treating this bill like Chapter 1 of the laws of Hong Kong. So are you being too harsh? Well, we have to stop at 12:45. I'll be brief. Well, I think Mr. Porter has expressed that viewpoint a number of times. So after you've spoken, we'll conclude. Well, I have to explain that absolutely we do not have that intention. Well, we understand that very often the money is locked up under a fund. So that's a good practice for a columbarium. But then the operator should let the consumers know so that the consumers will set their mind at ease when patronizing them. So the operator and the consumer, between them, they should strike a balance. So maybe we can go back and see how we can write this in a better way in order to attain a proper balance. Well, we've completed Schedule 4, Part 1. We also completed Clause 41. Members asked a lot of questions and raised a number of concerns. I suggest that at the next meeting, we start with Clause 42. Oh, we still have Part 2. Well, next time we'll start with Schedule 4, Part 2. All right, essential terms. All right, meeting adjourned. Thank you very much.